Hi, my name is Christy Fram, and I'm an attorney here at the Nieves law firm. And today I'm going to be discussing with you a case resolution that I was able to secure for one of my clients by getting a drug possession charge completely dismissed. The district attorney's office filed a misdemeanor against my client for alleged drug possession. And this complaint was filed in 2017. However, my client was not arraigned on those charges until December of 2023. That is approximately 6.5 years after the charges were brought against him. Those that are being charged with crimes have a right to a speedy trial, and that is a protected Sixth Amendment right. The district attorney's office took approximately 6.5 years to further the proceedings after filing the complaint against my client. The court can consider several factors when the defense requests a dismissal based on speedy trial right violations. The main factors that are weighed most heavily are the length of the delay, that is presumptively prejudicial, that the prosecution had no good cause for the delay, and that the person being charged suffered prejudice. In fact, suffered prejudice. Now, a 6.5 year delay is presumptively prejudicial for so many reasons. If the prosecution wanted to take this matter seriously and wanted to pursue these charges against my client, they would have taken several steps and several measures to make sure that my client is brought to court. However, my client was never searched for. There was never any investigation to try and find him, and he was always in the same county, same home, did not go anywhere. It's the government's job to bring those that they want to charge with crimes to the scrutiny of the government. They cannot expect a lay person to bring themselves to the scrutiny of the government. The prosecution had no good cause for the delay. There was no evidence or any documentation on the prosecution side showing that they took any steps to try and find my client. They took any steps to bring him to court. The biggest factor that the courts weigh most heavily is whether the person being charged actually suffered prejudice. And in this matter, my client did in fact suffer prejudice. Well, first of all, 6.5 years have gone by. The arresting officer or the citing officer memory has faded. We're humans, our brain capacity can only hold so much, and this officer has had hundreds of other arrests and citations and other matters that are very significant and definitely more significant than your typical misdemeanor drug possession charge. And so whether that officer testifies, his memory is not going to be accurate. There are also no CAD logs available with the communications between the law enforcement officers. And also the substance that the prosecution claims to be meth was not available for retesting. The prosecution was relying on a report that was rendered many years ago, and the defense had no opportunity to test the actual substance, and that is problematic. Ultimately, the court decided to grant my request to dismiss the whole matter. And so the matter was completely dismissed. My client was free of those charges, and the matter concluded.
Don't forget to like and share this video, and for more legal insights, keep watching and subscribe to our channel.